right, my friends, welcome back to the Weekend Interview Show. Elaine Cassel writes for FindLaw.com, practices law in Virginia and Washington, D.C. She teaches law and psychology. She's the author of the excellent book, The War on Civil Liberties, How Bush and Ashcroft Have Dismantled the Bill of Rights, and also runs a great blog, Civil Liberties Watch. Welcome back to the show, Elaine.
Hi, thank you.
I'm so glad to have you back on. February 10th, a jury convicted an attorney named Lynn Stewart of 5 counts of fraud, conspiracy, and providing support for terrorism. She's facing up to 30 years in prison. What support for terrorism did Lynn Stewart give?
Well, the prosecutor charged and the jury agreed that she did, mainly what she did was give her a statement to the foreign media, Reuters news service, that her client, Sheikh Abdel Rahman, was withdrawing his support for a ceasefire among his organization, the Islamic group, that had been suspected of being involved in some terrorist bombings of tourist sites in the summer of 1998, 1999. And
so they're saying that when she passed this message basically from Omar Abdel Rahman to the news media, that gave a signal to his followers that they were to start killing people?
Yeah, because it was, it was a proactive act on her part. He had been meeting in prison. When she got into the prison, she took along a translator because she did not speak Arabic, and also a paralegal. And the translator was charged with, convicted basically of the same thing that she was, while the paralegal was convicted of much greater charges to carry life in prison. But they apparently, the sheik apparently dictated the press release to them, and then they translated it and gave it to her, and then she sought out Reuters and gave the information to them. That's the gist of the thing. The prosecutor said that was in effect a, quote, jailbreak. She broke her client out of jail and allowed him to be in contact with his followers, which was the reason why the government had put its so-called special administrative measures on her and him.
Okay, now, let me stop you right there for a second, because I don't think you mentioned it, but Omar Abdel Rahman was convicted of bombing the World Trade Center in 1993.
Not actually of that bombing. He was convicted of doing things after the World Trade Center bombing that might have led to further bombing.
So he was convicted of the plot, the Lincoln Tunnel and the UN building,
right. And serving life in prison.
Okay, now there was more to this than just the press release to UPI, wasn't there?
To Reuters?
I'm sorry, yes, to Reuters. Wasn't there, didn't they accuse her of, saying irrelevant things really loud to cover their conversations?
We go back and do two things. First of all, her client was under surveillance through a Foreign Intelligence Surveillance Act warrant, so-called a FISA warrant, that allowed the Bureau of Prisons to conduct surveillance on him while he was in prison. But shortly after the Patriot Act in 2001, in October, Attorney General Ashcroft amended the Bureau of Prison Regulations to allow the government to tape record, videotape, and audio tape attorney meetings with certain clients. Now, Stewart was told that she might be a subject of surveillance, although, indeed, they never will tell you that you are under surveillance. And the government can do this now in terrorist cases. They have been doing it. They don't do it very often. So they did conduct surveillance of Stewart's visits after she agreed to these special administrative measures. But what happened was they were able, because they had conducted surveillance on the sheik, they were able to use surveillance when he was targeted and not just her. So they actually had her under surveillance and had her on tape from about 1998 on, before she even knew she was, in other words, she wasn't the target of the surveillance until she was, the attorney in 2001 with the new regulations. But she was in the room obviously. And then, so what she did, though, after she signed the agreement that she would not, she would only talk to him about, representation, that she would not speak to the press, she agreed to speak to the press. She agreed that she would not be in contact with the press, and that she would not deliver messages from him to the outside. Once she realized that she was under surveillance, which she was able to do by, looking and finding things in the room, or like going to the restroom, knowing she would be followed when she was at the prison, then she talked over, out loud while Rahman was with the translator and the other person doing his business, so to speak. So she tried to impede the government's surveillance, which she argued is only what a reasonable attorney would do, would be to try to keep their client from being, under surveillance. But she was not charged with obstruction of justice for that, but that was all part of the conspiracy charge.
Well, what they'll say is, why should a terrorist have a lawyer anyway? I mean, who cares if they violate this sheik's rights? Well,
yeah, I guess the problem is that the definition of terrorism is so broad that any of us, we could talk another time about the case of Ahmed Abu Ali in Virginia, which to my mind is a step beyond Lynn Stewart. We could talk about that another time. But, any of us can be charged with terrorism for anything, even for having a conversation about things that we disagree with what the government is doing. A conspiracy is nothing more than having a conversation and terrorism in the broadest definition is anything that's undertaken to influence government's action that may result in harm to somebody. So, you and I could be having a conversation, I could be on my cell phone and run into somebody, and that could be part of a conspiracy to commit terrorism. So, but, I don't think that too many Americans anymore have a problem with everybody having a right to an attorney. I realize there are some people way out on the fringes who say, just grab them and, shoot them. But that's a hard position especially for our government to take now when we're yammering at the rest of the world about civil liberties, which I think is rather, hysterically funny. We're telling Saudi Arabia and Egypt and Russia how we treat people, and they the point's well taken when they say, what about what you do to people? So I think that, we don't want to go down that road, at least the government doesn't, of denying terrorist lawyers. But the government is certainly making it harder and harder for people who are charged with terrorist crimes to have access to counsel, because they can be under surveillance, and who wants to talk to your attorney when in effect the government is listening to everything you say, listening and watching. And so if that's not a chilling effect, I don't know what is. However, Lynn Stewart was not the type to be chilled, so she was not intimidated.
Well, but she did sign, you said, the special administrative measures, which is basically a contract between her and the state saying she won't talk to Reuters, she won't deliver messages.
She did. I think that she was wrong to do what she did. I don't agree with what she did, and I wouldn't do it, and I don't support it. However, I think that in another time, I think the lesson of the Lynn Stewart case is in another time she might be subject to a bar complaint and some type of discipline or a minor charge, but she wouldn't be charged with terrorism because she happened to be talking to and about her client who was a terrorist. And I think when the verdict came down, and now, sad to say, Attorney General Gonzalez had his little piece, he said this is a message of terrorists and everyone who supports them are going to go down. Well, to charge a lawyer with supporting terrorism when she made a statement, well, I guess you would put it like this. It's not, to my mind, what she did is not much different from coming out of the courtroom and saying, my client is innocent, he didn't do it, she didn't do it, and we're going to fight this to the end.
Oh, now you're guilty of perjury, right?
Absolutely.
You're aiding and abetting your client.
Let me tell you that they are now trying to charge people, you've heard about this in some of the terrorist cases, with perjury because they made a statement saying that they're not guilty. You could even say now that a not guilty plea is perjury or obstruction of justice. So the absurd lengths to which the government is going to go to try to put a chilling effect on anybody it doesn't like. There's no doubt Lynn Stewart she was a target because of the type of work that she does. And there was no evidence that any harm came from what she did. It was something that someone like her would do, and maybe there's not many people exactly like her. And let me just say this. Another issue, I think, is that Lynn Stewart probably talked too much about her own case during the course of the trial. I mean, on the stand, she answered the question that she thought in some cases violence could be justified. In fact, we have a whole history, as she said, of violence in the United States to get what we want, right?
Well, our government's in the middle of killing people with totally no justification whatsoever right now.
That's true. But, that's not something a jury wants to hear, right?
Only the state's allowed to kill people, not
Absolutely.
you.
Only the state is allowed to commit terrorism, right? As long as the state. And so I think that I don't know. I have a hard time gauging what the judge is going to give her. I mean, given her age, of course she loses her right to practice law.
How old is she?
She's 65.
Oh, and she's facing 30 years.
Yeah, she'll lose that automatically, and it's gone now until she's overturned on appeal. And I think they've got maybe some mildly interesting legal issues, but in today's judicial climate, I don't think that there's anything yet. Now, there's one thing that I think that might possibly lead to reversal, and that was that the judge, for whatever horrible reason, allowed the jury to see a videotape of Osama bin Laden years ago talking about the Sheik. And this was long before Lynn Stewart even knew there was a Sheik.
Well,
and that videotape was played at the very end of the government's case.
I can't understand how the evidence of the eavesdropping and the surveillance of the so-called privileged conversations between her and her client were even admissible in the first place.
They're admissible.
Is there not grounds for the appeal to throw it out based on that?
No, because those regulations were not there. That was all tried in the early stages. When Ashcroft wrote that regulation as an executive order, which he absolutely can do. I mean, your listeners don't have any idea how insidious and evil executive orders are. Ashcroft woke up in the morning and decided, I'm going to put this order out that allows me to conduct surveillance on attorneys whenever I want to, and that becomes the law. And so, no, there's no real basis to overturn that, even though we don't agree with it. Ashcroft had the ability to do that. That issue of whether that is a violation of the Sixth Amendment has been litigated and lost. And I think that that's just one more example of a loss of liberty since September 11th. I mean, when you can't have private conversations with your attorney, then you have no right. You have no counsel. You have no right to counsel. The Sixth Amendment is just incredibly undermined. So I think I know lawyers who represent people in, quote, terrorist charges in Alexandria, Virginia, and I think that they probably are extremely careful what they say. But I really don't know how they're doing their job. And, of course, they can't talk about it either, you see. They can't talk about how it's impeding their job, because that in itself could be some signal that they are not obeying the mandate. So I'll tell you, it's a horrible situation. And I think that this will be extended. Keep in mind that this executive order of Ashcroft is any attorney and any client. It's not limited to terrorism. All right?
Really?
And so if you're in there for a DUI, right, driving while intoxicated, and they want to conduct surveillance on you and me while we talk about your case. Now, I qualify that by saying this is a federal issue right now. If you're awaiting trial or you're post-trial in a federal prison, then this applies to you. And the decision is made solely by Attorney General or his designate. So it's an unbelievable, arbitrary, discriminatory, capricious. He'll handpick the attorneys that he wants to conduct surveillance on. And the only reason he's doing it is to see if the attorney is committing a crime along with the client. Looking for a conspiracy, which is the case that they were able to make out in this particular case. So I think it's horrifying, and I think even representing your client. I mean, we talked about, does that mean you can't have an attorney? I think that the day will come when even representing a client can be considered terrorism. I don't think we're there yet, but I don't think it will take much for us to get there.
So if I'm a lawyer in Austin, Texas, and the court tells me that somebody's been accused of terrorism and they want me to be that defendant,
attorney, right? Because she was court-appointed
attorney, right? Now that I have this client in a terrorism case, and I look at the Lynn Stewart case and I see what happened to her, how does this change the way that I'm going to be able to defend my client?
Well, I think that you would have to, I can tell you I haven't talked to the lawyers who are doing it because I don't think they'll talk about it. But if it were me, I could tell you that I would be it would be extremely difficult to do that because your client could tell you nothing. Everything that your client tells you could possibly be used to bring additional charges against him or her. Could be used to, so in other words, if you have committed a crime in the past, okay, your lawyer has no obligation to report that. If you are about to commit a crime and I can't stop you, I have to report that. But if you come in and say, Elaine, I killed somebody 20 years ago and I'll tell you where the body's buried, I'll probably say, don't tell me where the body's buried and let's go on to the next topic. But I don't have to report you. However, if surveillance is being conducted, then I put you at risk as your attorney for asking you facts, for discussing normally what you're supposed to discuss with your attorney, which is tell the truth about everything that would implicate you in the case. But that could certainly put you at risk for additional charges. And I really think that that's more the target of the regulation. I think it's really to find out more what the client is saying because very few attorneys, what Lynn Stewart did was minor, and most attorneys are not going to be colluding with their so-called terrorist clients. But I think in terms of what the client can tell the attorney, then that, I think that the attorney is going to have to be very careful about what he tells or what he gets the client to say. So I just think it's looking down the road. I think it's going to be used in other cases. It's not going to be used in just quote terrorist cases, and I think it's going to change forever the right to counsel. I think that we are looking at now with Gonzalez and Michael Chertoff at the head of our Homeland Security. I think we've got serious troubles ahead.
It brings up the question of why we even have a Bill of Rights in the first place. Was there some sort of moral reason, like maybe that government can't always be trusted to get the right guy, and we got to put the burden of proof on them?
Yeah, but we don't believe that anymore, right? I mean, don't we believe that our government is infallible now?
Oh yeah.
And
all right, hang on, Elaine. We'll be right back, everybody.
Okay.
It's the Weekend Interview Show. Weekend Interview Show. I'm Scott Horton. The guest is Elaine Cassel. She's a defense attorney in Virginia and Washington, D.C. She's the author of a great book called The War on Civil Liberties, How Bush and Ashcroft Have Dismantled the Bill of Rights. And she runs a great blog. I suggest you Google it, called Civil Liberties Watch. Now, Elaine, pardon my redundancy, but aren't the court decisions explaining the way that the Sixth Amendment is to be applied, don't they override change in regulations by John Ashcroft or an Alberto Gonzalez?
Well, I mean, so I guess that this will be ultimately appealed now that she's been convicted.
Well, but I mean, isn't this already established that you can't eavesdrop on a lawyer and their client?
It's established law now, but the regulation itself has not been decided whether that's going to be constitutional or not. But see, here's the problem. Because it was issued as a regulation that has to do with the Bureau of Federal Prisons, it is very hard to overturn a regulation. This is not like Congress passed a law. This is part of, administrative law. When it's for instance, let me give you an example.
It would seem to me, and I'm not a lawyer, but it would seem to me that it would be easier to overturn some dumb regulation made by an executive official rather than a giant law passed by Congress. It's much harder
to overturn regulations because of the nature of administrative law, and if it's within the power of the agency to take action in order to protect not only protect the national security, but having to do with prison discipline and visiting hours and things like that. If it's within the purview of the agency, it's very hard to overturn a regulation. That is why people need to be more aware of the extensive amount of government that is being done by executive order. So, for instance, don't you think that Bush changed constitutional law when 4 years ago he entered an executive order directing the federal agencies to proactively allow government funding to churches?
It would seem that way to me.
That was incredible.
I can't even imagine why the churches would want the federal money in the first place.
Oh, well, some of them do. The ones that want to be his mouthpiece. I was just at a seminar last week at the University of Virginia on that very topic. So the Pat Robertsons and the Jerry Falwells, who are already, arms or agents of Bush, they certainly want the money. Now, and the very poor churches, let me tell you, Bush is now going out, and one of the people that was at the panel works in the administration, and he goes out and actively seeks black churches, small black churches, to give government money to. Now, those are the people that are going to be very beholden to the administration, and as a point was made by someone else, this is so evil what Bush is doing.
Jesus says, vote Republican.
Here's what he's doing. By getting the churches to accept money, in effect, the churches that come to depend upon it will become silent and never criticize him or his administration. Now, we know that Pat Robertson and Jerry Falwell never criticize his administration, but think about the role of black churches in the civil rights movement and where we would have been in this movement if we did not have black ministers. Now, what if today, if that happened today or back then, if all those churches were receiving what for them could be a lot of money, several $100,000 a year for an after-school program or something like that, or a drug program, do you think that they would be marching in the streets? I doubt it.
Nope.
And isn't that just in fact, the whole day to go down there was worth hearing that. Isn't that just a brilliant strategy?
That's government absolutely out of control.
Absolute brilliant strategy.
Hey, everybody, look up the Civil Liberties Watch. It's a great blog. And the great book, also, The War on Civil Liberties, How Bush and Ashcroft Have Dismantled the Bill of Rights. Thanks very much for coming back on the show, Elaine. I always appreciate you.
Thank you for having me.
All right, take good care.
Bye.
All right, everybody, we'll be right back with Eric Margolis.